Hey guys, how's it going? So recently my friend John Crump of AmmoLand and YouTube broke a story about rare breed triggers being determined a machine gun by the ATF. And by now a lot of you are already probably familiar with that letter that the ATF wrote with their so-called determination, as well as a cease and desist for that company to stop, commencing with these triggers, making them, selling them, etc. Now, I'm going to go through here and read a letter to you and show it here on the screen in 1 second. That is the response letter from the Law Office of Kevin C. Maxwell representing rare breed triggers. So they wrote a letter to him. He wrote a response. I think this is really interesting, and I haven't been able to find any videos on this. So hopefully all of you guys find this interesting. Now, when you're done watching this video, go down below in the description. I'm going to leave a few links. First of all, to John Crump's channel. Make sure you go check him out and subscribe to him over there. Also, my other channel, Patriot EDU. I've been doing some videos talking about these triggers, as well as I think an important video talking about why bump stocks are still technically illegal, and the Chevron deference, and how this all ties in with each other. So I'll leave a link to that down in the description. And of course, if you'd like to help my channel, there's links down there too where you could help out if you'd like. And please share this with all of your friends, because this other letter has been going around like crazy. But I don't think many people have really seen this letter yet. And I'm going to read it to you. I know you guys know how to read, but a lot of viewers tell me you guys like to listen to my videos while you're driving to work, hanging out with your earbuds, your Bluetooth, whatever. So I'm going to read it and offer a couple of my thoughts. So this comes shortly after the letter the ATF wrote rare breed triggers, and this is dated August 2nd, 2021, and this is addressed to Mr. Craig Sire, Special Agent in Charge, Tampa Field Office. And it says, regarding, in response to cease and desist, rare breed triggers FRT-15. Dear Special Agent in Charge Sire, I represent Rare Breed Triggers, LLC, RBT. I write in response to your letter dated July 26, 2021, the letter, which was provided to me by hand delivery on July 27, 2021, by you and Amy Fryermuth, Esquire. Your letter dated directs RBT to, quote, cease and desist all manufacture and transfer of rare breed triggers FRT-15, and to contact ATF within 5 days of receipt of this letter to develop a plan for addressing these machine guns already distributed. That's in quotes. The letter bases its directives on an alleged examination finding that the FRT has been properly classified as a machine gun as defined by the National Firearms Act, NFA. While the letter refers to such examination in the first paragraph, I say alleged above because you stated during our July 27th, 2021 conversation that you have not seen any examination done by the ATF concluding that the FRT is a machine gun. Interesting. Neither has Ms. Fryermuth seen any such examination, and neither of you had a copy you could provide. I wonder what's going on here, guys. I'll continue. While I thank you for your frankness, courtesy, and professionalism during our meeting, I must dispute the letter's claims in its entirety and demand strict proof of same, including an unredacted copy of what I expect is a report of technical examination from the examiner within the firearms technology branch. In the absence of that, I must demand an unredacted copy of whatever other examination, in quotes, led to the issuance of the letter. RBT disagrees with any conclusion that suggests the FRT-15 can shoot more than one round by a single function of the trigger. This is not just my opinion. Before the first FRT-15 was manufactured, the design was reviewed in detail by retired Special Agent Kevin McCann, Esquire, and former ATF Senior Special Agent Program Manager and Chief Firearm Technology Instructor Daniel G. O'Kelly. The conclusion of that review determined the FR-15 is not a machine gun. The letter does not reveal the method of testing or examination applied by the Tampa Field Division in concluding that the FRT is a machine gun. I understand you have never seen the report upon which the letter you wrote is based. However, this omission is quite a concern to me. The letter's failure to identify a legal standard or address apparent conflicts with past rulings or approvals causes great concern about its legality. As I am sure you are already aware, the Administrative Procedures Act sets forth the procedures by which the ATF is accountable to the public and its actions are subject to review by the courts. The Act requires the ATF to engage in reasonable decision-making and directs those acts to be set aside if they are arbitrary or capricious. In addition, the Supreme Court of the United States has held that where an agency's prior policy, such as here with a prior similar design approval, has engendered serious reliance interest, it is arbitrary or capricious to ignore such matters when attempting to change such a policy. As a result, to change policy, the ATF must display awareness it is changing position and provide a reasonable explanation showing the agency believes the new policy to be better than the old policy. Since your stated position is based on your application of the definition of a machine gun under Section 5845B6 of 26 United States Code to the FRT-15, the ATF must present how and why it has the authority to change its prior interpretations of the NFA. I sincerely hope the ATF did not base the letter on a video depicting a semi-automatic rifle firing while equipped with the FR-15. We both know that a firearm's cyclical rate is not relevant, let alone dispositive, as to whether such a firearm is a machine gun. Rather, whether a firearm is a machine gun is solely dependent on 26 U.S.C. 5845B. The letter fails to comply with these requirements or to reflect your determination can be reconciled with the prior decisions reaching conflicting results. Rate of fire. The whole bump stock thing, remember? That is what the ATF was alluding to in there, is a rate of fire. This is important, and a lot of this stuff ties together. Remember to check that video down in the description I did on my Patriot EDU channel. There's a whole thing going on here, in my opinion. RBT has the highest regard for the law, and the cornerstone of such law is basic concept of due process, which includes notice and the opportunity to be heard. The letter demands that RBT cease operation without advising it of how its product allegedly violates applicable law. Moreover, the letter is signed by you, in your capacity as a law enforcement officer and an officer of the court, without you having personal knowledge or any knowledge of the alleged factual underpinning of the letter. Respectfully, how can you have signed the letter in good faith under these circumstances? I write not to be confrontational, but the letter seems like a charging affidavit written by a police officer who did not witness the event and who does not know who did. No court would rely on such affidavit, and I very much expect the same result here. Why would RBT take the penultimate step of ceasing its operation when not even you have a factual basis for the letter's conclusions, let alone RBT? Tremendous time, resources, and money have been invested in ensuring RBT is compliant with the law, creating and sustaining its operations, and its overall success in the marketplace. RBT cannot reasonably meet the ATF's demand under these circumstances. As you should know, the ATF's Firearm Technology Branch has approved a forced positive reset trigger in the past, and that design remains approved to the best of my knowledge. I had heard people talking about something like this in the past. Let me know in the comments if you guys are familiar with this prior trigger. So it says, to the best of my knowledge and belief. See, October 31st, 2013 letter of the approval of the 3MR trigger. I've never heard of it before, but I've heard people talking about it a little bit. The FRT-15 is a forced reset trigger, as is the 3MR trigger. Neither converts a semi-automatic firearm into a machine gun. The letter improperly threatens criminal prosecution without proper notice. This makes the legality of your determination even more unreasonable. The Supreme Court has ruled that due process bars enforcement of criminal statutes where an agency improperly changes course with respect to conduct it deems unlawful. This is because an improper regulatory change or reinterpretation makes it impossible for the average person to know what is illegal. The letter is just a change, just such a change because, as pointed out above, Technical Branch has previously concluded that a trigger with a force or positive reset similar to the FR-15 trigger assembly is not a part or combination of parts that will convert a semi-automatic firearm into a machine gun. Further, the ATF has never announced any change in position, nor promulgated any publicly available notice of its reinterpretation of their prior approvals. In short, the ATF is unable to legitimately do or what it threatens to do in the latter. Fair and proper notice would also extend to the thousands of Americans who purchased an FRT in reliance on the ATF's past interpretation of the NFA. In recent case of Geddes versus Bureau of Alcohol, Tobacco, Firearms, and Explosives, Justice Gorsuch explained how ATF's bureaucratic pyriding on the interpretation of a different federal gun statute forced, quote, ordinary citizens to guess about how best to confront their conduct to the law. Justice Gorsuch's revelation of the harms that result when ATF reverses course underscores the need for ATF to carefully consider the effects of the letter both on RBT and thousands of law-abiding Americans, and to ensure that any policy changes follow proper procedure. The letter also states the NFA levies a $200 tax on each firearm made and an additional $200 tax on each firearm transferred. Your letter seems to imply RBT could pay the taxes on the FR-15 and continue production as a Class 3 item. Was that your intent? Because while you've suggested in the letter RBT could be required to pay the $200 tax to manufacture and the $200 tax to transfer each FRT-15, you failed to indicate how that would be possible. Instead, the letter demands RBT to develop a plan for addressing those machine guns already distributed when no such machine guns exist. Further, as alluded to above, RBT did its due diligence before manufacture of the FRT-15 began. Attached, please find an opinion letters of Kevin McCann, Esquire, Daniel G. O'Kelly, Rick Vasquez, and Brian Lutkey, all former ATF experts. RBT seems to be the only one here who has done its due diligence prior to acting. RBT must defend its interest from what certainly appears to be an overreach. Please note that I do not intend here to besmirch you. I understand you have superiors. Please also understand, however, that the orders you're asked to follow relating to RBT must have basis in law and fact. Must have basis in law and fact. I stand ready to receive the information demanded above. Until then, RBT must respectfully decline the letter's demands. Make no mistake, RBT will fully cooperate with any reasonable ATF investigations. However, it cannot simply acquiesce to the destruction of its business based upon ATF fiat that finds no support in its prior rulings or applicable law, rule, or regulation. I have left you 2 voicemail messages to see if you withdrew the cease and desist. When I did reach you, I spoke to your legal counsel, Amy Fryermuth. I asked her of my request and my intent to seek declaratory and injunctive relief, a preliminary injunction, and a temporary restraining order. The correspondence is not and should not be construed as a full treatment of the issues raised in the letter. RBT reserves the right to reevaluate its position after receipt and review of any additional documents the ATF elects to provide. Sincerely, Kevin Maxwell, Esquire. So there you guys go. This is the first time that I can remember that when a company got a letter to cease and desist or some kind of declaratory letter stating something's a machine gun or it's illegal or all these different letters we've had over the last few years. This is the first time I can remember the company actually writing them an official response letter back and then publishing it to the public here. So, I don't know, guys. This is kind of crazy. This letter I'm getting from the infidel.co. Allegedly, I mean, I didn't get an original copy, but it appears to be a legitimate letter on what appears to be the official stationery of the law office of Kevin C. Maxwell. I think he brings up a lot of really good points. What do you guys think? Let me know down in the comments. It looks like they're fighting back. It looks like he was pretty clear that they are not going to oblige the cease and desist letter. Yeah, right here. It says that they're not basing it in any... It must have basis in law and fact. And they're basically saying these are all baseless claims. Which, yeah. Right here. I stand ready to receive the information demanded above. Until then, RBT must respectfully decline the letter's demands. It appears by this letter that they're going to keep making whatever it is with the triggers, selling them, things like that. And I showed a video just a couple days ago on my Patriot EDU channel where it appears they're still selling the triggers. That may have changed in the last day or two since then. Stuff always changes fast, but wow. There's a lot to this. Not to mention all of the work John Crump's doing undercovering the standard operating procedures of the ATF and certain branches and how they do things. Lots of good videos coming out on the John Crump News channel regarding that too. This is crazy, guys, isn't it? Literally, there's a lot going on right now. And that's why I did that video that's linked in the description talking about Chevron deference, this 6th Circuit Court of Appeals case that's going on right now in Western Michigan. The full panel is hearing this case as we speak. Very, very important. Literally, all of these things hinge upon the Chevron deference, and I went into great detail on how that works and why it doesn't matter if you care about the bump stock. It doesn't really matter if you care about the FRT, the rare breed trigger. You should care about what's going on with the ATF, because this is all just keeps stacking up. The more they keep getting by with it, in their mind, it's going to become status quo. We just can't let this go on. So this is literally, we're right now kind of sitting there with the pendulum swinging, and what way is it going to go? So far, it's not going very well, but we really, really need to win in the federal 6th Circuit Court of Appeals. That would actually change a lot in 4 states, right? Michigan, Ohio, Kentucky, and Tennessee, but then hopefully SCOTUS would take the case and make this nationwide precedence that they can't use this Chevron deference anymore, which is what all of this stuff is hinging upon. I covered it very thoroughly in that video. I don't normally plug a video this much, but check the description, guys, for that Patriot EDU video. Definitely go over to John Crump, because there's lots and lots of information that I think will help you guys all, hash this out and kind of sort it out in your head. All right, guys, let me know what you think of this letter. I think it's very interesting. I think there was lots of good points made, and I wish rare breed triggers well. All right, thanks for watching, and have a good one.